Hey, everybody. Welcome back to the weekly immigration news recap, where we break down what changed in U.S. immigration this week and what signals came from the Trump administration that could impact your immigration situation if you're a foreign national, or your client strategy if you're an immigration practitioner. Today is Thursday, August 14th. It's about 1:20 p.m. Eastern Standard Time, and this episode is going to be released tomorrow on Friday morning, August 15th. Sorry we missed last week. I had some Wi-Fi issues at the very remote and rural town that I was visiting at the time. But to make up for it and to cover all the news that we missed, I'm really lucky to have Meagan Kirchner, founding attorney at Kirchner Law, joining me today. Meagan, thanks so much for taking the time to recap the news with me this week. We'll get into all of your many impressive bona fides and sort of your background in a minute. But first, tell everyone where you're joining us from and how your summer's going so far.
Thanks for having me. I'm joining you from Central Virginia, pretty rural, about 45 minutes south of Charlottesville. We're in the balmy midst of the humid summer, and it's heavy in the H-2B season for me. So it's in a grind right now.
Were you born and raised in Virginia or elsewhere?
I've been in Virginia since I was about 9. Spent the first part of my life in Maryland along the Potomac.
What's one fact about the DMV region, DC, Maryland, Virginia region that people who maybe aren't from there, who haven't visited there, wouldn't know? What's one fun fact?
Oh, a fun fact. Oh gosh. Well, I mean, maybe there if you weren't there, but the restaurant scene is so diverse. It's one thing being out here in the middle of Virginia that I'd miss is having the option to have so many different cultural experiences. Just going, into DC, into Arlington, Fairfax, like there's lots of fun, like cultural things that you can do there. And it's also fun that you don't know. People probably don't realize, you think DC and think big buildings and traffic, but if you just go a little bit outside, you get quick views on rolling mountains, or, you can go into Maryland and go on the bay and get crabs and fish and fresh seafood. And so you don't have to travel very far to experience not just the cultural immersion of being in Washington, DC, but you can get, a little taste of Maryland, Virginia, and West Virginia pretty quickly.
I can attest to both. I can especially attest to the diversity of the food. That was one thing when I moved from Maine and went to college in DC, that I got to try different cuisines that I would have never had the opportunity to try, like Ethiopian food, Somalian food, Afghan food. There's so many little immigrant pockets throughout the DMV area where you could just get some amazing food.
Yeah, it's definitely took it for granted while I lived there.
Yeah. Well, before we jump into the news and sort of recap some of the headlines from this week, you just tell folks listening a little bit more about your background, your current practice, and the types of clients that you work with.
Sure. So I've been in immigration for 12 years now. It's been a while. I started out doing pretty boutique EB1, NIW self-sponsor petitions, did a stint in big law, did some EB5 work. So I've done pretty much your alphabet soup of business cases for the most part. Currently focused very heavily on H-2 visas, so agricultural and your blue collar skilled labor, seasonal labor. So work with a lot of small businesses, mid-sized businesses, and it's really fun because it kind of takes me back to my roots, because it's really connecting with people that are just like everyone I grew up with because I grew up in rural Virginia. And so it's really a nice practice area to kind of marry past, present, and future. So,
yeah, I mean, a lot of the other attorneys that we've had join on this podcast tend to come from the employment-based side of immigration things, but they come more from the H-1B world, right? And sort of everyone conflates that with tech or with white-collar jobs, office jobs, that type of thing.
Exactly.
Can you give some examples of the types of clients that you work with for H-2Bs or H-2As?
Right. So H-2A is all agricultural. So you're talking about farms, whether it's, flowers or fruits and vegetables, livestock. So that's a pretty big chunk. H-2B is much more diverse. What people are probably going to think of is like landscaping, construction, hotels. What people don't see a lot is like seafood processing, carnivals, and really a lot of different businesses can be seasonal. Like I just had one that was a trucking company, and it's usually a lot tougher to get trucking, but they had a true like their client base, the whole reason for their business operations, are kind of surrounded agricultural and food like supply chains. So, they needed dispatchers. They didn't need drivers. They need people that got the trucks where they're going and making sure all the loads are getting scheduled and, things aren't rotting, clients are getting served. So really, H-2B is typically, like your really easy cut and dry seasonal. Like if you think of it, you think of snow, you think of weather, you think of tourism, but it can be so much more than that, just depending on what someone's actual business operation needs are.
Yeah, it's fascinating. I think, during the first Trump administration, I remember there was a lot of media coverage on the
Oh,
H-2 programs, and a lot of like Americans and even like immigration practitioners, experienced immigration practitioners in other areas were sort of exposed to the importance of the H-2
right.
programs for the first time. And there was obviously some issues, and I'm sure we'll get into that with
Yeah.
processing for H-2 and sort of the,
Yeah.
the system that needs to be taken in order to for an employer to obtain an H-2 visa in a timely
Right.
manner. But it's fascinating how connected the H-2 program is to the broader economy,
Oh
right?
my
Not
gosh.
just tech
Yes.
firms, but so many different local businesses and regional
Yes.
businesses that are so important to people.
Yeah. It's funny you mentioned that because I know this is a news focused podcast. So like it's been in the news constantly and it's becoming very, very clear how important, even within the government, like they're realizing people that are hardline conservatives are like, wait a second, we're doing all these deportations, just picking people up. There's whole job sites now that have no workers, right? So where were those, kind of the reality? I've had a lot of people contact me who have had either undocumented workers or something like that. And they're like, how can I make them legal? And it's like, well, I can't necessarily help that now, but you're seeing firsthand, like all these industries are going to need to funnel somewhere. And we've got H-2A and H-2B, and they're not perfect. So we're going to continue to see how this is not able to keep up with the demand to fill these slots.
Right. And there's caps, just like with the H-1B, which will be a good segue into our first topic. But
Yep.
I'll just sort of talk about what the agenda is for today. So Megan and I will spend the next 30 minutes or so breaking down all the important developments that happened in immigration news this week. And despite it being mid-August, there are still new developments happening in the immigration news. We'll focus mainly on what's happening inside of the Trump administration, but we'll also look at some of the litigation updates from the courts and any new developments from Congress. Both of those areas a little bit less this week. And then in some cases, we'll just recap the headline just so you all who are listening, get the gist of what's happening on a certain story or topic. But because Megan is an expert in H-2 visas specifically, we're going to go a little bit deeper in some of those areas today, which I'm excited about. And then at the end, Megan, no pressure if you don't have one, but I always like to save a little bit of time for the guests to talk about a trend or a story that you've been keeping a close eye on, but
Sure.
maybe hasn't gotten a lot of coverage or attention in the media or within the immigration practitioner community. So it's sort of flying under the radar. So we can save that one for the end. But ready to jump into the news, Megan?
Yeah, sounds good. Ready to go.
Awesome. So our first story is that on the USCIS website, Megan, I'm sure you're super familiar with this,
Yeah.
but for the folks who are watching and can see my screen, or for the folks who are listening, I'll orate sort of what we're looking at. USCIS provides an update on the H-2B cap count for the two different halves of the fiscal year. And maybe you can explain that in layman's terms so the folks who are less familiar with the H-2
Sure.
program can hear that. But right now there's an update on the numbers of how many approvals there have been for the first half of fiscal year 2026 for the H-2B.
Sure.
So Megan, maybe start by just explaining the difference, or how this H-2B cap works and why there's two
Sure.
halves and all the nuances.
Right. So the H-2B cap is only 66,000 a year. It hasn't changed since the 90s. Despite the whole world changing so much since then, labor force. It's divided into two halves. The October 1st is one aligns with the government fiscal year. It resets. 33,000 get released October 1st, 33,000 April 1st. That's impactful because the only way you can get an H-2B visa is if you are be able to be successful going through Department of Labor and then filing with USCIS before this cap count hits 33,000. And really, if you can do everything right in the first step with Department of Labor, but if there's no visa cap left, barring some other strategy that you've talked to with your attorney, you're not going to get workers. So a few nuances there that maybe it's not quite so black and white, but the cap really determines whether or not you get workers. And it's a little less impactful for the October cycle, but it's, you know, the randomization gets done regardless of the cycle, which is where every employer gets put in a pot and they get a group assignment. And that's going to dictate, it's not like H-1B where it's a true lottery, you get selected or you don't. It's just your processing timeline and your processing slot is going to dictate whether this chart means you can get workers by the time you get there through that process or whether they're gone already. So,
Right. So right now, sitting at August 11th, 2025 was the last time this count was updated. There's
right.
been about 4,000 cases approved, and there's about 7,000 that are currently pending. Is that,
Right.
in your experience, normal for this time of year, or is processing with USCIS and DOL slower, or is everything sort
Right.
of going as normal right now?
So USCIS is processing, timelines, at least almost all H-2B cases, are processed with premium processing. So, they're kind of moving along normal pace as far as the behind the scenes adjudication. Sometimes they're kind of tracking all the way through to you're getting close to that 15 days, whereas historically maybe it was only 3, 4, 5 days and then they're approved because they're pretty quick. But as far as how many have been approved to date, DOL is tracking ahead of prior years, which is going to then trickle down to USCIS likely moving further ahead. It's about 2 weeks, last I heard, ahead of what processing was last year at Department of Labor. So the cap was met mid-September last year, where we might be in August this year when that cap gets met for the October 1st. And it seems like every year this October 1st cap gets met a little earlier because people are kind of funneling out of the April 1st, trying to find different filing strategies, maybe filing, there's also more demand because there's just the labor market is so tight. So everything seems to be moving just a little bit faster and demand every year goes up a little bit more.
With your clients, when do you start preparing for the first half and the second half
Yeah.
of caps for these
Yeah.
folks?
So I prepare a little bit earlier than some other colleagues I've spoken to, just because I've found so much administrative error at Department of Labor with either prevailing wages or, difficulty getting a SWA set up in any certain states. So usually I send out contracts in like February and start doing wages as early as March. Some of them end up first week or half or so of April is pretty common as well. I take them on a rolling basis in the fall because I have more time to prep. It's a little different for the October cycle because you file on July 3rd and you don't have as much time for the prevailing wage to not expire because you only have it through, for 3 months if it's too close to the end of the flip over for the wage rates. So if I get a wage and for the second half of the fiscal year for April 1st and I submit it in July or August, I have time to refile that wage if it's wonky. For instance, I get it back from DOL and it's off by 1 digit on the occupation code. It's clearly clerical error. It's faster to refile it than it is to appeal it or request them to fix something. So I start my April cycle in July or August. It's a lot of lead time.
How much of the process is because like H-1Bs, for example, right? Like LCA takes 7 days to get certified.
Right.
It's pretty quick. If you're filing for an H-1B or a lot of the other non-immigrant employment-based visas, the Department of Labor plays a small role in that. And then we get to the immigrant visas and the perm and the green card process takes a lot longer. What's it like on the H-2B front? Is the Department of Labor the bottleneck or the place where things can get clogged up or there's more work to do, or is it USCIS?
It's absolutely DOL. They are better this year with processing times. It's still a long, long time for the April cycle. October is much more predictable for at least the 9142 for the actual H-2B application. Those are something for the spring, like you're looking at April, you file the case in January. Depending on what group you get slotted in, some of those employers are languishing at DOL just waiting for first action on their case from January. They don't get first action until April. It's just sitting there. You can't take steps with USCIS till that's done. Prevailing wages are much better than on the perm context. It's 30 days, 35 days right now. Last year some of them were pushing 45, 60 days. So the prevailing wages are much faster, more in line with historical norms right now for H-2B. So that's a nice plus. I don't know what the reasoning behind that is, how they're managing to do something faster, but I'll take it.
So that was going to be my next question. This news is a little bit old, but I know you've posted about it on LinkedIn, and I just sort of want to get your thoughts on it. But
Yeah.
and I'm sharing my screen here with
Yeah.
the official memo. But at the end of June, and this was sort of, if people remember, in the news
Hmm.
at the time, this is when the National Guard was in Los Angeles. There were a lot of workplace raids, including on farms in LA County and Oxnard County in Southern California,
Hmm.
and sort of the H-2 program came front and center in the news as, hey, here's one of the legal pathways that immigrant workers can be working on these farms.
Hmm.
And so during that time period, this memo was released by the Department of Labor talking
Right.
about the creation of this new Office of Immigration Policy. And it was
Right.
sort of broadly reported that one of the key goals of this office was to make H-2 processing in particular a little bit more streamlined.
Right.
I'm just curious, what's your take on the creation of this office? Obviously, we haven't heard a lot since this memo came
Yeah.
out, so
Yeah.
I know it's sort of shrouded in mystery, but what's your take
Yeah.
on the creation of the office and DOL in general under the Trump administration?
DOL has been so far under the Trump administration, just broadly, functioning mostly as business as usual. It hasn't been too jarring yet, and even processing times have improved. Again, I don't know what the reasoning behind that is, whether it's related to the administration or just broadly policy changes that have allowed them to process things faster right now. Um, if this office actually came to fruition, I'm not quite sure what the purpose of it is exactly, and whether it's just going to kind of give them more benchmarks or give them a new streamlined way to do H-2A. I've heard that in the past where they want to have H-2A that, all on one platform, have that process go in a little more streamlined fashion. I don't know what that's going to look like. Um, they were originally trying to have the head of that office be someone who's very familiar with the H-2 programs over from ETA. So if he were to take up that office or take up that position, that would be a positive development because he's very intimately familiar with how the process works. And that would be a welcome person to be in that position to hopefully facilitate some meaningful change or some, better training, something to get the, programs to function properly. Because what I do encounter a lot with the H-2 is just, I don't know if it's improper cross training. Because a lot of times analysts will get pulled from Perm or pulled from some other program and get stuck in H-2. And H-2 is so very different than all of the other programs that sometimes you get a boilerplate request, and it's like you just really don't understand the program. It's not really an issue with the application. It's just a training issue or some sort of misunderstanding, at that level. So if the office can streamline things or have better training in place, then I'm all for it. I just don't know what we're going to get from it, or whether it's more of a formality.
Yeah, it seems, and again, I'm much more of an outside observer on the H-2 program than you are, and you've this is something you've been this is an area that you've been very closely observant of for a long time and been on
Right.
the ground actually doing the work. But politically, it seems like the
Hmm.
H-2 program has a lot of bipartisan support, right?
Right.
And there's a lot of political pressure. There's a lot of lobbying
Hmm.
efforts to improve the H-2 program. What's sort of your take on where that stands currently in the Trump administration? If do you have what's your outlook on if there'll be improvements made potentially to H-2 program?
So there's a lot of balls up in the air right now from the lobbying side, with possible not I won't say solutions because I don't know that it's actually going to solve everything, but improvements, right? Process improvements, cap improvements, something to take the pressure off of the cap or processing times, right? There's lots of things that are different avenues they could take, and they really try them all concurrently, hoping one of them will stick. Um, from what I've heard sitting in on the lobbying calls, it's or calls with the big lobbyists for the H-2 program that really, they're the ones that meet with the administration. It does have, unlike many areas of immigration, it does have bipartisan support and lots of different states. It touches every congressperson's constituents. It's
Right.
everyone's lives. So once people come to realize that, it gets support, but there's so many other players and factors going on. Like in prior years, there's been a fatal flaw with the unions not agreeing with it, or this state wanting more visas, or this state wanting more restrictions. And it's just very I don't want to be negative. I'm hopeful that there could be some meaningful change. I'm not confident or expecting it necessarily. There's lots of good ideas to try and take some relief off of that cap, or reallocate things. And we could talk about what those options are later when we talk about other, points that are going on in H2. But I'm just hoping for status quo at this point, quite honestly, which would be, if we can get supplemental visas like we have had in the past, I would be super excited because I know how to advise on that. I know what to expect. I can strategize for that. Right now, we're in that weird gray area where you're trying to advise clients in the hope that there's supplemental visas. We don't know how this administration is going to treat it yet. And so you're also kind of having to have dual conversations like, well, if this happens and this is the strategy, but if this doesn't happen, we're going to have to fall back on this option that's not going to be as favorable. And there's going to be more risk because there may not be any relief on the cap, right? So
Yeah, it's fascinating. It's a program where I think urgency and certainty for the practitioners and for the employers and for their employees, their H2 employees, is so much more important than in other areas. With the H-1B lottery, it's, a lot of folks going in know that their chances are slim, 25,
right.
30%. And even if they do get the visa, they're very aware of the timeline. With the H2, it's just things are a lot more urgent. And I imagine not having that certainty or that transparency from the administration could be a lot more detrimental than it can be for some of the other employment-based categories. On that same note, this story is it's a couple weeks old, but it's worth revisiting from the context of the H2. It was announced a few weeks ago that the State Department, effective September 2nd, is going to be updating eligibility for the visa waiver program. And under the Biden administration, right, the eligibility was expanded.
Right.
It helps cut down wait times at consulates abroad, specifically for H and all H holders, but H-1B is sort of predominantly what we covered. I'm curious, is this going to be? And I've heard a little bit, or I've seen a couple of attorneys post about it on LinkedIn about H-2 applicants now potentially being required to do interviews at consulates abroad prior to coming to the U.S. Can you maybe talk about the impact of that?
Right. I just talked to one of my recruiters today. And H2, unlike other areas, it's very common for employers, attorneys, agents to work with recruiters, or maybe there's also called agents in some contexts. Basically, there are firms that have offices in the countries that you're recruiting from. They can help with DS-160s as well as, recruiting, sourcing workers, making sure everybody gets to the consulate, because places like Mexico, it can be difficult for workers to get safely to the consulate. It's an in-person required process for paying the fee in a lot of cases. So I was just having a conversation this morning asking, well, what are we in for this fall? Like how far in advance am I going to need to tell people that these appointments are going to be backlogged? And he just told me this morning, in Mexico specifically, which is one of the largest sources for H-2B workers, is going to have probably approximately a 30% reduction in appointment availability. So we're gonna be processing pretty darn slow compared to what we have prior years when we had that expanded waiver program. That's going to further backlog an already overstressed, oversubscribed program that has tremendous backlogs with DOL and cap issues. So it's going to be bad for the H-2B side that I'm working on. For the H-2A side, I mean, that is the difference between a crop getting harvested and a crop rotting in the field, whether the workers get here on time. So it's kind of to be determined how much of an income impact it actually has. But that was the estimate I just got this morning.
Yeah. Again,
just for one country, but
an important one, right? I didn't have the time, but I was looking at the monthly visa issuance statistics, and I was trying to get a sense of, which consulates throughout the world tend to have the highest number of H-2B issuances. A lot. Mexico popped up right off the bat. Some in Eastern Europe as well for H-2Bs in South America. But it sounds so. My question for you is, at what point in the process, DOL, USCIS, visa interview at the consulate, where does that take place in the process?
The consulate happens the very last step.
Okay.
H-2B in most contexts is different, again, than a lot of other visa types. You can do unnamed petitions. So the company's certified and approved for 25 workers. Their approval notice says 25 unnamed workers. So at that point, once they're approved at USCIS, they can take that approval notice to any consulate they want to and start scheduling visas or appointments for their prospective workers. And so you're going to get through that whole process and potentially already be months behind, depending on where you fall, say for spring for a 4/1 start date. And, with this additional backlog for consular appointments, if you're already looking at April 15th that you get approved and now you're just now scheduling consular appointments, in a good year, you have 2 weeks lead time. That might be a month now,
Historically, were many of your clients able to get the waiver, or was that not something that was available?
It was pretty widely available because a lot of the workers have had H-2s in the past. So
Got it. So you did it last year and you can.
Yeah.
Yeah.
Like you may get like if you've got most of the workers that had in-person appointments required were new, had never been to a consulate before, or maybe they had prior waivers or administrative processing or something like that. So they go back in for another interview.
So now it's the double whammy of more interview requirements, and also because all the other categories have interview requirements too.
Exactly.
It creates the backlogs. Yeah.
Exactly.
Yeah. Yeah. Well, not to segue this into another concerning story. At least this isn't a reality quite yet.
Right.
But last week, the Secretary of State, the State Department announced a new visa bond pilot program, which would essentially institute anywhere between $5,000, $10,000, and $15,000 that a visa applicant would need to pay in order to come to the country, and they wouldn't receive it back until they returned. I have a quick clip here of Secretary of State Marco Rubio talking about that in an interview, so I'll just play it, and then Megan, we can get your reaction.
You are instituting a pilot plan where people who are coming to the country to visit, when they file for their visa, they have to leave a bond of $10,000, $5,000 for children. Why are you instituting this? And is this going to help people actually go back to their country?
Yeah,
I know that's what
it's not for every country. It's for countries that have high rates of visa overstays. What generally happens is people will get a visa, they come to the U.S., it expires in 6 months, and they don't leave. Now they're here illegally. Very common. And it happened a lot. In fact, I would say at one point, I don't know what the latest numbers are, but more than half the people in this country illegally were visa overstays. So for countries that have high rates of visa overstay, you post the bond, and the bond gets collected against. And obviously, so obviously now some third party is going to try to verify whether this person is truly going to come back or not. But I'm not saying it solves all the problem, but it's an innovative way to sort of cut down on visa overstays.
So right now, this pilot program is only being introduced to 2 countries. And only for B1, B2 visas. But the word pilot is key, right? And as the Secretary of State just mapped out there, the goal of it is to decrease visa overstays.
Right.
The Department of Homeland Security released a report in 2024 using 2023 data of all of the estimated overstays from each country. And that's it, supposedly reporting it says that's part of the countries that the State Department may look at in terms of expanding this visa program, but it could also be expanded beyond just the B1, B2 to other visa categories like the H-2. So first, curious for your reaction on Secretary Rubio's statement there, and then maybe give you a broader analysis of this program and the implications of it if it were to expand.
Right. I mean, just watching the clip, it seems obviously overly broad, much like it always is. It's the 2 I think they picked. I don't remember exactly what the statistics are, but from a percentage basis, it's not anywhere near it may be a high percentage of the number of visas that they issue, but the number, if you were to just look at other countries on the number of people that actually overstay, there's so many more countries that have thousands more overstays. So I guess that, I'm curious how they decided which country is going to be in the pilot program and why. And I'm guessing, it's kind of one of those things that you wonder if this is just more optics or whether it's just, good for a news soundbite and good for their hardline stance, or whether they're actually, like you said, concerningly pilot, if they're going to roll it out to other visas, countries, et cetera. That would have, just from an H-2 standpoint, it'd be catastrophic. No H-2 worker could post any kind of bond. There's no way. And no employer would be willing to do that or be able to take out enough to actually staff their workforce. So I don't know how practical it is going to be to roll that out for employment-based visas in any context, whether that's H2 or H1 or L1. It doesn't really matter. I don't know if that's going to be practical.
Yeah, and you'd hope that again, sort of the bipartisan, general bipartisan support for the H-2 program might shield it from it being included in the program. But yeah, like you mentioned, be it agriculture or be it a seasonal business, I worked at seasonal businesses my whole life. You have no money until the end of the summer or the end of the winter.
Yes.
You have zero money in your bank account as a business,
right?
To really pay any of your workers, let alone a $15,000 bond.
Right.
I did crunch the numbers. I'll share my screen from that DHS report that I mentioned. So for the folks who are watching, they can take a look. But I posted about it on LinkedIn, and I'll share that in the post as well. So the two countries that are included in the pilot right now are Zambia and Malawi, and they, according to fiscal year 2023 data, had visa overstay rates for the B1, B2 category of 11.1% and 14.3%. But like you mentioned, Megan, right, if you actually look at the raw numbers of the estimated visa overstays, it's about 237 folks, 237 individuals in total that are estimated to have overstayed their visa in 2023 from Malawi, and then 388 from Zambia. So it'll be interesting how this pilot expands, and like you mentioned, which criteria they use to expand it. Because if they go purely off of the overstay percentage, well, how much of a problem are you really solving at that point, or the problem that they're outlining, right? Are you solving at that point? But if you go for countries like India that have a lower overstay rate, 4.7% for the FM&J category, but 7,000 predicted overstays, that's going to start impacting a lot more people.
Sure.
Mexico, Chile, India, any of the countries that have tens of thousands of immigrants, hundreds of thousands coming here on non-immigrant visas every single year, that starts to add up with a $10,000 or $15,000 bond.
Absolutely. It's just be really interested to see what the true intent. I understand what they say the intent is, but with the practical impacts they'll have for selecting some of these countries, I just don't know if they're going to achieve their actual goal.
And you heard Secretary Rubio say it, like he used the word, this is an innovative way to address this overstay problem, right? And so there's clearly a team at the State Department, maybe in coordination with some of the other immigration agencies in the White House, that are trying to figure out a solution to the problem of overstays, and this is what they've come up with. So this is not the last chapter in this story, in this development.
Absolutely.
I think it's fair to say. Yeah. Okay, next story is, and we've talked about this before on the podcast because it's sort of an ongoing saga. But there was a rule that was introduced just before July 4th that got a little bit of press coverage on changes that are being proposed to the H-1B lottery. And so this proposed rule is referred to right now as the weighted selection rule. We don't know anything about it other than the name and the fact that earlier this week, or I think late last week, our friend Andrew Craigbaum over in Bloomberg Law reported that it cleared White House review. And now any week, we should expect text of what the actual rule is, what the proposed changes will be to the H-1B lottery from USCIS. And then it would, in theory, go into a public comment period so that folks can, from all sorts of different interested groups, can comment on the rule, and then it'll go into sort of final processing with an expected intention by the administration to have this change be implemented going into next year's lottery.
Right.
Megan, you can comment on the H-1B rule if you want, but I sort of have an H-2 angle that I wanted to run by you as well.
Sure.
Before we do that, there is a paper that was released by the Heritage Foundation on the same day that this rule cleared White House review, which could be a coincidence, could not be. But it's by a researcher named Alexander Fry. The paper's called Rethinking the H-1B Visa Program, a data-driven look at structural failures and the high skill illusion. I'll link this so folks can go and read it themselves. It's actually a really interesting paper, and I think it gives a very good overview of, I think, what the Trump administration's view is on the H-1B visa, but specifically the wage aspect of the H-1B visa. So this paper outlines ideas for what a weighted selection could look like. The rule that's about to come out, that we're about to see the text of, could draw from this paper. It's entirely possible. For people who know that there's a revolving door between the Heritage Foundation and the White House and the Trump administration. But one thing in there is replacing the lottery with a wage-based ranking system that would, and this is quoting from the paper here, would curb abuse, prioritize high-skilled roles, and better align with the program's original goals. Long preamble there, but Meagan, obviously wages, right, and wage determinations with DOL is a really important part of the H-2 program as well. What's your take on how the Trump administration may maybe potentially scrutinize more the wage determination process for H-2s? Or have you seen any issues with that in the last 6 months since they've come into office?
I'm not sure how they would plan to change it necessarily, but there have been this past year, it's 2024, so coming up for this 2025 season that we're in right now, well, there were some states that had tremendous increases in the H-2B wage. I mean, we're talking $1 or more, same county, same occupation, which is normal year over year. Not year over year, but over a few years, maybe you'll see that kind of swing, but not in one single season. And it was many different occupations, many different states, and it's a pretty big sticker shock for a lot of employers. Fortunately, most of my employers already were paying their U.S. workers more than that because that's just the U.S. labor market. But or their the H-2B teams make more than that because they're keeping them up all in the same wages. So it was still very impactful for others that were much smaller, and maybe their teams were smaller, or they're in a locality that they just don't charge as much for their services. Maybe they're in the same MSA, but they're further out in the outskirts, but the same wage, same MSA. It's a big difference so to have that kind of jarring change in one season, whereas normally you have a few cents here, a few cents there. I've even seen some years where that drops 5 cents, right? Like the wage data just proves that's what the wage is when the government releases the wage data. So from an H-2B context, just as far as if they were to increase those wages even more, it not only prices out the foreign labor, so it's not just going to price out H-2B labor. It may be a situation where some employers, they just work on less staff and they don't have as much growth and they don't have as much business. So you and I have fewer people that can come help us with jobs or tasks, or maybe there's fewer people being staffed at the resorts. So, because it's not by choice that they don't have workers there. It's not because they're not paying them enough money necessarily. They do the wages. Like I said, in some contexts, the U.S. workers are already making more, and they just still can't keep staff, can't get more staff. There's a supply demand issue. So it's a situation where, with corresponding wages, if they try to price out, the immigrants to drive the U.S. wages up, that might work. I don't know for sure that it wouldn't. I'm not an economist. Some economists say they will, some don't. It just depends on what data they're pulling from, right? It's a, kind of an interesting concept to try and research, but it's just like with the H-1B, where we talked about a minute ago, if they go wage-based and only do high wages, there's a lot of jobs that aren't going to get filled. I know their best intention is to hire American first. But the way the recruitment's set up, it's already designed to do that. And the wages already are such that, it's supposed to be industry standard. So if they increase it artificially, it's not just going to impact foreign labor. It's going to impact the ability to recruit local labor as well. Yeah,
it's a really interesting point. And I think, again, also not an economist, so take this with a big grain of salt, but one of the common, from policy folks who are very focused on the H-2 program and the benefits that it provides to small businesses and just the overall American economy, a lot of the wages that a lot of the roles that these H-2B or H-2A employees are coming to fill, the market has already driven up the wage that has been offered to Americans far above the prevailing wage, right? Like for the hourly rate. So for the most part, the wage that could be offered to Americans is and Americans still aren't taking those jobs, which is why the employers seek out the H-2 visa as an alternative solution. It's so much higher. So I maybe someone will do some research. I know maybe I'll do a plug to some of my friends in the think tank world to go dig into the H-2DOL data and do a report on sort of prevailing wages versus actual wages and what the roles for those are. That'll be an interesting one.
Right.
Okay, just a couple of more stories that we'll just we'll cruise through here. Another update from the rulemaking process from the White House. So there was another rule that was introduced also just before July 4th that cleared White House review and is now like the weighted selection rule for the H-1B cap. Is moving on to the next steps. Again, we don't know much about this proposed rule other than its name, but a lot of speculation that the rule is trying to eliminate duration of status for certain visa holders. Most commonly, and I think probably most predominantly, would be F1 students who, when they go to a consulate overseas, apply for a visa. On their visa stamp, it grants them entry and exit for the duration of the status, which is typically tied to the duration of their schooling. Meagan, some of the concerns I've heard on this are, from folks is, well, like plans change often when you're a student, right? You may transfer universities, you may take an extra semester, you may graduate early, you may get OPT work authorization, and your status changes. And if they end duration of status and you have a fixed period of time on your visa, it's going to basically leave you with two options. One, go back overseas to renew your visa, which can be very difficult and costly, and you're sort of rolling the dice. Or two, file an extension with USCIS, which isn't a common practice now, and we'll see how that turns out. But any reaction to this rule?
Yeah, I mean, it's just another one of the rules that just feels arbitrary and it's not actually accomplishing anything. I don't know what the purpose behind this is, for what problem they're going to solve. I mean, they're definitely going to run more petitions through USCIS, so their filing fees might go up, but then their backlogs are also going to go up because all of these different programs we've kind of talked about today are all getting more things funneled through there, or the consulate, more demand, more backlog, more waits. So regardless of what their purpose is behind this, it's going to cause slowdowns either way. Either you risk going to a consulate and getting denied, and also spend resources having delays, or you're going to go through, having to go through an extension process, and that's, getting an attorney involved, and then, wait, and hopefully, you don't run out. It doesn't stay pending so long that you run out of your ability to work or do your OPT or something like that.
Yeah. Exactly. And then we covered this, a few months ago too, but the pause in visa appointments for FM and J visa applicants, again, contributed to the current visa appointment backlog. And I've seen a lot of universities that are projecting that they're going to see 20, 25, 30% fewer international student enrollment this year as a result of that policy, and other factors, but in part as a result of what happened there. Okay, so just two more quick stories that we want to cover, Meagan. Typically, like I said, we cover what happens in the Trump administration, the courts, and in Congress. In terms of updates from the courts this week, there wasn't a ton. That I saw in the news, but was there anything happening on the H-2 front in the courts that you think folks should be paying attention to?
There wasn't exactly in the courts. It's related to pending court cases. Like, there were lots of the H-2A rule that passed in 2024. There was a lot of different lawsuits filed. It was very fragmented in its enforcement, which states had an injunction, which did not, and whether that rule applied. And with all of that fragmentation, we don't know if the administration's going to tackle it a different way or reintroduce its own form. But there was a notification about a month ago for a plan to rescind that rule, which is now in a comment period. So not directly related to court, but certainly something to keep track of, because it's, we don't know what's going to happen with that yet, but it is something that will impact H-2A broadly, kind of across the board. So all those pending court cases are kind of still at issue, and they may become obsolete if this entire thing gets rescinded. So, yeah.
Okay, and then in Congress, the House and Senate both remain in recess until September 5th, so no significant headlines on the immigration front from Congress this week. But Meagan, since you're here, we'll look back to some news from Congress from a couple of weeks ago, which is the Dignity Act, which has been getting a lot of attention as a proposed piece of bipartisan immigration reform. unless I completely missed it, I know there's the Dignity Act was originally introduced in 2023 and was reintroduced earlier this summer in 2025. I didn't see some of the H-2 provisions that were in the 2023 version added to the 2025 version.
No.
Obviously, when a bill is introduced, that's never going to be the final version of it if it makes its way through Congress.
Right.
But I figured it was worth taking a look at the H-2 provisions in the 2023 version of the bill,
Sure.
and just sort of having you explain like maybe why those provisions are in there,
Right.
And what the motivations behind them are. So
Sure.
this is a recap from the National Immigration Forum. They did a summary on the bill. And I thought it captured it pretty well. I'll leave it on the screen so folks can read it, and I'll link the National Immigration Forum piece into the show notes so folks can go ahead and take a look. But yeah, Meagan, what are sort of the key things that are needed or that are being lobbied for H-2B and H-2A reform?
Sure. So here from the 2023, they were really pushing for the returning worker exemption as a solution or like I said, a pressure relief valve for the H-2B cap, right? So this iteration was really trying to make it was very worker focused. So if a worker had been on an H-2B visa once in the past 3 years, that worker doesn't count against the cap. So that 66,000 number doesn't change. But a large portion of H-2B workers have done this for years and years. So essentially, if they meet that qualification, they don't count against the cap. So you increase the cap by not applying as many people to the cap, right? So that was the thought process behind that. And that is also still, at least in prior 7 years, the way they count returning workers for what we call supplemental visas that they issue via the federal rulemaking process every year, which we're on pins and needles to see if they'll do that for 2026. Well, we don't know yet, new administration, but that's the same concept. That's in its current version. It's something we have to wait for every year versus just being something that exists every year. We have more predictability if it were something that was passed permanently, right? So that was the thought process behind that one. Current pushes to solve issues with H-2B aren't focused on this anymore. This one didn't get a lot of traction, like with the unions. So it got stripped, and like you said, isn't in the current version. What they're really pushing right now is what we call a certified seasonal employer program, which is more employer focused. So really providing or rewarding H-2B employers that have complied with the program, done everything right, and have been doing the program for a long time. So the current wording that's really floating around Congress and was tried to get it into the big bill, didn't make it, tried to get it in through, the other processes. There's still things in motion, but the thought process there is, an employer that has been in the program certified for 5 years, and the last number that they were certified for, say it's 20, they are permanently exempt from the cap for those 20 workers. If they increase, then they're going to have to enter the lottery for those 5 new ones they need. So it just gives again, not changing the cap officially, but changing it by default by having not as many workers funnel through that.
Sure.
So that's the current biggest push they're working on. Again, bipartisan support, whether or not it actually gets through all the different channels it needs to and to come into fruition, whole another story. They're still working on the same version of the supplemental cap that we've had the past 3 years, including winter, and 7 or 8, including the spring, because spring had supplemental visas long before winter did. That's something we're still trying to get in. The broader industry is still trying to push for is at least, like I said, status quo and have the same expectation that we've had for the few years. From H-2A's perspective, they had a similar process to try and get workers here longer, less having to do with consulate, just streamline it, right? That's really the process, because H-2A doesn't have a cap like H-2B does, but it's still a very arduous process to go through for both the workers and the employers. So, the goal is always to make it a little easier, maybe a little less costly, maybe more predictable, like just know how it's going to work, what timelines are going to look like, which agencies are going to go through, and how long it's going to take. Because right now it's just, it's very fragmented, especially with the state workforce agencies and all working a little differently. It makes it difficult, and even advising is, you get a new state you haven't worked in before, you have to learn how that state is going to tick.
Sure. It's so much more tedious than the H-1 program, which I think most people would say, like, be like, what? No, there's no way it'd be more
Right.
tedious than the H-1B. But I mean, the fact that, an H-1B is valid for 3 years,
Right.
right? And
Exactly.
in H-2, you got to redo this every single
Right.
year or every 6
Exactly.
months in some cases, right? That's so I'm glad there's people that are pushing for reform, obviously. Because it seems like you mentioned, the unpredictability of having to rely on the executive branch to, with a swipe, with the stroke of a pen,
Yeah.
create a last minute change that impacts so many employers, and obviously your practice and your clients. It must be a little bit unsettling for everyone involved.
It makes it very difficult for sure, to make it palatable to everyone that might otherwise use it. It certainly would be more widely adopted if it was more predictable, because usually people have the need and are willing to pay the costs, but not knowing whether or not it's going to work is a big turnoff.
Yeah. Well, Meagan, before we wrap it up here, I want to just, give you the floor. Are there any trends or stories or signals that you're paying attention to in the immigration world?
Yeah. I
Go ahead.
mean, I'm sure you've probably talked about it before, but the visa integrity fee right now that they're talking about for October 1st is a big one that I'm watching personally in the H-2 world, because we don't know in the H-2 context who's going to be responsible for paying that, because all the visa fees fall on the employer right now. But if this is a refundable fee that the employer pays, but the worker gets back when they prove they leave, how is that actually going to come into play? Who's responsible for that? If the employer pays it and the worker gets it back, so how do they make sure the worker gives it back to them? Do they have to hope the same worker comes back and that worker pays the fee, and then it's, they're using the same money they gave them? Just procedurally, I'm very curious to see how we're supposed to pay it, who's going to be responsible for it. I just don't know. And that's something right now with my employers or my clients that I'm just letting them know it might come down the pipeline and be an additional fee they're responsible for. I can't say for certain, but I want to let them know that basically the consular fees are more than doubling for their H-2 workers.
That was part of the One Big Beautiful Bill, right?
Absolutely, yeah.
Right. And so there hasn't been any new guidance given from the government on
officially.
Right.
So,
And then it's a good point that you make too, right? Like, different contexts will have different procedures, right? Whether or not it's an employer sponsored visa versus an individual visa or a family visa. Like, again, who's responsible for, or a K-1, like a fiance, like who's responsible for paying that is a big question. So hopefully we'll get some clarification on that.
Yeah, and then even with the clarification, if it's employer responsibility, that's a big cost for people with a lot of workers. And if it's the worker responsibility, a lot of workers can't pay that. They don't have $250 to come on an H-2 visa. So employers are still probably going to pay for it.
Yeah. Well, something we'll keep an eye on then going forward. But Meagan, that'll wrap us up for today. Thank you so much for taking the time to join me and to recap the news. And it was really fun for me to sort of get to look at the news through the H-2 context and get to draw from your expertise and your insight on everything that's happening in the immigration world on the H-2 front. Before we go, tell everyone where they can follow you and your work or get in contact with you.
Yeah, they can find me on LinkedIn, probably, and that can connect you both to my website, my Instagram, I have Facebook if you need it. My email's on my website. It can be meagan@kirchnerimmigration.com. So there's many ways you can try and catch me. Just use everyone works best for you.
Awesome. We'll put the links to all of that in the description below so folks can reach out and check out. Well, Meagan, thank you again so much. And we'll have to have you back on again soon to talk about H-2 stuff. And hope you have a good rest of your summer.
You too. Thanks for having me.